Good evening, honorable members of the Executive Council. My name is Rhonda Tapley, and I am here to speak to you today on behalf of my family to oppose the appointment of Robert Lynn to the New Hampshire Supreme Court. My husband, John, and I have been residents of Merrimack, New Hampshire for 24 years. Our daughter, Erica, has been involved in a parenting matter in the New Hampshire court system since 2005. Judge Lynn was permanently assigned to her case in 2007. I am here to share with you today our family's firsthand observations of Robert Lynn's performance as a judge and why we believe he is not qualified for the job of Supreme Court Justice. In 2003, a person came into our lives and brought with him an extensive documented history of domestic violence and sexual abuse. This person is the father of my 6-year-old grandson. He is currently a registered level 2 sex offender in Massachusetts. He has pled guilty to aggravated felonious sexual assault in New Hampshire, and kidnapping, assault and battery, and indecent assault on a person 14 and over in Massachusetts in a previous relationship. He has a significant mental health diagnosis, and from the disclosures of my grandson, his father has allegedly sexually abused him. In 2005, our daughter went to the court for protection and relief. My first observation of Robert Lynn was during a hearing in January of 2008. The hearing was held concerning a psychological evaluation of my grandson. He had been diagnosed with PTSD and speech and language delays. The psychologist initially recommended a hiatus in visitation with his father to allow for further medical evaluation and to determine if the visits were a factor in the child's PTSD. No other requests or modifications were requested by any party at the time. My initial impression from the remarks that Judge Lynn was making during the hearing was that he had arrived at the bench with his mind made up before he heard the evidence. Judge Lynn ignored the psychologist's recommendations and ordered my grandson to be removed from the safety of the supervised visitation center and allowed parenting time with his father with no professional supervision. No relief was provided for the child. Erica's attorney and the guardian ad litem filed motions to reconsider. They were denied. Erica filed a discretionary appeal with the Supreme Court. It was declined. During this hearing, as well as subsequent hearings, we found that Judge Lynn refused to accept any evidence that contradicted the prejudgment of the case. This was manifested in the courtroom and in his orders. When he issued his orders, they could be lengthy and appeared detailed. To a person that is not familiar with the case and was not present in the courtroom, his orders might appear logical, but when they are scrutinized, it is clear they are not reflective of the record. For example, he misquotes the testimonies of professionals, misinterprets medical evaluations, and then draws conclusions based on inferences and innuendos that are not reflective of the record. Large portions of relevant testimony and evidence are completely omitted as if he had never heard or read them. He ignores uncontradicted medical testimony and recommendations regarding medical issues. Evidence or testimony that does not fit into his preconceived opinion is simply deemed to have no merit. He makes statements on the record and then contradicts himself in written decisions. His demeanor on the bench can be abrupt, abusive, demeaning, sarcastic, unnecessarily harsh, and impatient. The comments that he includes in the footnotes of his orders can be vicious and cruel. In March 2008, an ex parte hearing was held, and during the hearing, Judge Lynn made it clear by his tone and demeanor that he was angry with Erica for filing the appeal. He commented on the record, "I didn't misapprehend anything about this matter. This was simply an interim parenting plan, and I fully understood I would hear further evidence in this matter." Effectively, he had modified a parenting plan without request from either party or the guardian ad litem before hearing all of the evidence. This was our first experience with the backlash of Judge Lynn's anger when you challenged his decisions. The new visitation schedule began. My grandson's therapists and teachers noticed significant regressions in his behavior. In June 2008, he returned home from a visit with his father with an injury. The guardian ad litem filed an ex parte motion for relief. This was the beginning of what was to become a continuing spiral of injuries, disclosures, trauma, therapy, forensic interviews, and DCYF and Massachusetts law enforcement involvement. If these injuries and disclosures involved anyone other than his father, common sense alone would dictate no unsupervised contact. In December 2008, as a result of Judge Lynn's demeanor, prejudice, and failure to correctly apply the law, Erica's attorney requested that Judge Lynn recuse himself. He refused. In March 2009, at final hearing, His therapist, the guardian ad litem, and DCYF all concurred that my grandson's unsupervised parenting time with his father was causing him great distress. During the hearing, Judge Lynn heard testimony regarding the father's significant mental health history, father's family history of domestic violence, and father's history of abusing other women, including my daughter. Father also reported he suffered from sexual abuse from a family member. The woman he raped and kidnapped testified about the assault and kidnapping, as well as her personal observation of his family history of domestic violence and abuse. No professional contradictory evidence was ever presented. During the trial, Judge Lynn continued his remarks on the record, indicating his impatience and his unwillingness to remain open-minded and impartial. Before he had heard all the evidence, he made comments such as he was skeptical of Erica, and even if he were to assume what she was saying were true, I haven't heard anything that changes my mind. This trial is over on Friday. Judge Lynn stated that he would not be convinced that my grandson's father was a risk or had any inability to parent him and keep him safe until someone presented him with physical evidence that he had recently committed multiple serious crimes, such as abusing a string of other women, 3 DWIs in the last 2 years, fights with men, or constantly fighting with others. He erroneously focused upon criminal acts beyond reasonable doubt that my grandson's father had committed and did not focus on inadequate parenting behavior. These remarks indicated he was applying the incorrect standard of evidence for parenting matters. Evidence that was previously presented supported the fact that the father had already abused a string of women, raped, kidnapped, and assaulted one of them, had a history of substance abuse, had violated probation, had allegedly sexually abused my grandson, and failed to follow previous orders to learn about his son's mental issues. Erica's attorney submitted a memorandum of law detailing New Hampshire RSA 461A6 in the best interests of the child, in an attempt to clarify the standard of evidence for parenting matters. Despite her effort, Judge Lynn issued an order on custody and support, which had been statutorily abolished in 2005. He did not issue the required parenting plan. He ignored the concerns and recommendations of all of the professionals involved, but most of all, he provided no relief for an innocent 5-year-old child